Is Ms. Treadwell on the docket today?
She is.
Okay.
She's
Did you guys, are we doing it today or what?
we would like to, Your Honor. So, I approached on Monday on this, and you granted us Santa Maria. I was mistaken in that Santa Maria allows children of Brianna's children's age there. So Brianna, she had been working with Santa Maria Hostel, and the LCDCs there had been speaking with her about the Women with Children program. And that's what I thought I was approaching on. Okay, the Women with Children program. Apparently, Santa Maria and the Women with Children program, Santa Maria, are not one and the same. And so that is what we would request. We want the Women with Children program.
So the Women with Children program is a community residential program. She'll have to go through that process of getting enrolled there.
But that's not through Harris County.
That one's
No.
not through Harris County.
I can't, that's not something that we can,
Court order it is what we're saying.
we don't, it's not part of our like regimen, so to speak. There's not been, accepted to be part of like HUA, SADF, DDRP. That's their own thing. And so.
Whoa, did you catch that? The judge just made it clear, not every rehab or treatment program can be court-ordered. Even if it sounds like it's part of the system, it might not be. This is where defendants and lawyers have to really know the fine print or risk a major setback. What do you think? Should courts be allowed to force entry into third-party programs?
So it's not geared for.
Okay, I need to sharpen up on that one. I was understood. Okay. And so Santa Maria via the 6-month program. Okay.
It all depends on her. It all depends on her. If she responds well to treatment, yeah. But if she doesn't and she puts up a fight or she's like defiant and not doing what she's supposed to be doing, then it could.
When she's been in a program for 2 months now, Your Honor. And I believe Ms.
I don't want to do this again, and we've done this like literally.
Understood, but I guess at the least, Your Honor, if Ms. Treadwell could at least address the court,
No. We can just get it done. Please. All right, so Ms. Treadwell, you're charged with 2 counts of driving while intoxicated. I think the agreement is they're going to dismiss 1, right?
That's correct, Your Honor.
Is it 18 months this time, or is it 15 months?
It is 18
18
months
months.
this time.
Okay, so Ms. Treadwell, like I said, you're charged with 2 counts of driving while intoxicated. You have worked out an agreement where they're going to dismiss one of those cases in exchange for your plea bargain agreement. On the second case, the agreement is 180 days in jail to be probated for 18 months. As part of this agreement, you will do a TRAS, which you have already done to comply with the TRAS conditions. You will do a DWI repeat offender education class, 4 victim impact panels, no breath test refusal, meaning that if you were pulled over in a car, an officer asks you to submit a breath test, you must do it while you're on this probation. If you don't, then you're in violation of this agreement. You must do no drugs, no alcohol, random testing, $100 on donation to the Houston Food Bank, 20 hours of community service. You do have children, right? I think that we would better serve a parenting class instead of the 20 hours of just mindless.
Yes.
Are you okay with that, Blaze? A parenting class in lieu of the community service? Okay. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accuser. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you accept this agreement. There's no turning around. There's no coming back. You are on a probation. If you violate this probation, we will issue a warrant for your arrest. You will be looking at 180 days in jail if you do. Do you understand? Okay. Does she have any prior DWIs?
No, Your Honor.
This is just these 2?
These 2,
Okay.
yes.
How do you plead to the offense, guilty or not guilty? Okay, I'm gonna find you guilty. I'm gonna follow the agreement, sentence you to it. Now, she's going into treatment. Does she go in now?
It's up to you. I can have her do a walkthrough or she can wait in custody. It's about a 2-month wait.
We would request if she can remain out in the community until.
Do you have a scram on now?
She does.
I don't know what device she has on.
What does she have on now?
There's both scram and a GPS.
Okay, I'm okay with that.
Thank you, Your Honor.
I'm okay with waiting on the outside. Just remember, you're still under bond condition while you're waiting. If you fail to turn yourself in, a warrant will issue and you're looking at a ton of time. You understand? So don't do anything you shouldn't do because it's only going to end up with a further sentence. You understand? Okay, so are you going to get in contact with her when the bed opens up and then she goes?
Yes, sir.
Okay, all right, ma'am. Now, you need to understand for the rest of your life, when you get pulled over, all officers look are how many DWIs that you have. You ever have a funky smell in your car, whatever it is.
Okay, let's pause. Did you feel that tone shift? The judge just went from courtroom formal to full-on life coach. But honestly, this moment hits hard. It's a raw reality check. One DWI sticks with you forever. One slip, and it spirals. She's not just sentencing, she's begging this woman not to throw her future away. Powerful stuff.
It's probably not going to go well. So for the rest of your life, even if something magical happens where you're going out and you have half a glass of wine, don't get into a car. From now on, you're also facing a minimum of 30 days in jail. You understand? Okay, good luck, man.
Courthouse judge?
You can run a CC. Okay, all right, good luck. Please see.
Mr. Fleming, first name is Hayden.
Okay,
He is in the courtroom.
it's a
It
DWI.
is not. It is a.
It's a gun case.
Gun in a car. There was a felony drug case that was filed, which made the gun a crime. The felony drug case has been dismissed.
Blaze, balls in your court.
Yeah, so, Your Honor, that,
Was it pursuant to like a RIC or something like that, or?
It was pursuant to there being no lab report.
yes.
So what was allowed?
There is no lab report.
So, I mean, I told against counsel, I mean,
What do you mean there's no lab?
we never got a lab report back on the underlying felony. So they dismissed it.
More common than you might think, Your Honor.
Really? What, I mean, does it just fall through the cracks? What the hell?
Judge,
Does the officer submit?
It's a matter of time, Your Honor. The labs are so backed up that the DA's office has just said,
Case that everybody's now, what's that case that everybody's citing now? Heath, is it Heath? Yeah, it's Heath, right?
Yes.
Is that the one
So the
that's,
thing with Keith is though, is that we don't, the difference with the labs is, the felony where you get screwed with the labs is you hit your indictment time, and you're like, no, I'm glad that can't do that. With Heath, I think technically his lab reports aren't in our possession. It's the DA's office or the state. It doesn't become a Heath issue, but I think it would because the police are considered the state. It's not a lot, but this case, it's more, you run a issue with the grand jury indictment in the timeline. And if you get it there on bond, you get 180, you don't have a lab report, you can't take that in a grand jury. At which point then they're by law.
well,
so if you dismiss this case because there's no labs, how do we go forward?
That's what we're approaching.
we're asking you to reconsider probable cause, Your Honor.
Come up, Mr. Fleming. What was the alleged substance, cocaine?
It was.
Yes, Judge.
Yes.
So, Mr. Fleming, you get one life. You don't get redos in this life. And I can tell you how many lives I've seen ruined because they party, try to have fun, and you unfortunately get something that's laced with fentanyl, and then you die. Now, or worse, you become a lifelong addict, and you start doing crazy ass things that you would never do just to feed the habit. I've seen people deteriorate before my eyes here because they get hooked, and it's just so sad the stuff we've seen. Don't ruin your life. You only have one. You need to make the best of it. You get into school, get knowledge. Knowledge is power. And when you have knowledge, you can do things. That's how you make money. This life is about one thing, money. And when you have it, life is freaking great. When you don't, it freaking sucks. I'm telling you, don't waste it. I'm going to find no probable cause in your case. Do something worthwhile. All right. Thanks, guys.
Mr.
Okay.
Duffy.
Good luck, Mr.
Excuse me.
Yes. Mr. Roberts, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 180 days in jail to be probated for 18 months. Is this right? You look confused.
No, he's only expecting the probation. He knows that he's not going to have to go to jail.
Right. So it's 180 days in jail. I probate that for 18 months. You will not go to jail as long as you fulfill the conditions in this case. As long as you fulfill conditions and you do everything you're supposed to, you don't test positive. We all do backflips. What goes wrong is when you don't do what you're supposed to do. You pick up a new case.
Sorry, the offer was for 15 months. I think I made a clerical error and wrote 18 months instead.
Is this correct?
Yes.
Okay, so we'll fix
I'm
it.
sorry.
That's not a big deal. Let me ask you this. Was there an accident in this case?
There was, yes, well, he was asleep next to the train track. So yes, he was off of the road and had crashed through the train track.
It was his own vehicle.
Yeah,
Okay, so there's no restitution to someone else?
Yes, sure.
That's my concern.
Yes.
Okay, because my concern is that if you do something to yourself or your vehicle, I don't care. If you do something to someone else, then I care. Right, so hopefully, lesson learned, right? Hopefully, you don't get to where some people only learn the hard way. They got to hit rock bottom. They don't get it until they go into here, right?
This right here is your wake-up call. Texas doesn't play with DWIs. That search charge he's talking about? It's a surcharge thousands of dollars on top of probation, court fees, and classes. And yes, it sticks for years. Should first-time offenders face such steep consequences, or is it necessary to deter repeat offenses? Let us know in the comments.
You've worked out an agreement. They're offering you a 15 month. You want me to?
I'll bring it out right now.
It's a 15-month probation. You need to understand that this DWI will go on your record. It's going to be there forever. You can never take it off. And this is important because from now on, I don't care if it's a year, 2 years, 10 years, 15 years. If you get pulled over, officers will see that you're a prior DWI. If you smell like alcohol, if you smell like dope, it's probably not going to go well for you. From now on, after today, you're facing a minimum of 30 days in jail for any new cases that you pick up. No more proverbial slaps on the wrist. Do you understand, Mr. Roberts?
Yes, sir.
For you to successfully complete this program, you must first do a TRAS. This is an evaluation to see what conditions you may need. If they assess other conditions, you must fulfill them. It could be supportive outpatient treatment. It could be, intensive outpatient. I don't know, but we have clinicians that will interview you to determine, is this the right type of program for you? What you must do is a DWI education class, 4 victim impact panels, no drugs, no alcohol, and a guardian interlock and a random urinalysis. Is this how you understand the agreement?
Yes, sir.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So that's why I said, because you give up this right to appeal, once you accept this agreement, there's no turning around. There's no, you know what, I changed my mind. I want to do something else. This isn't Target. You can return it. You understand? The other thing I want you to understand, Mr. Roberts, is that we all make mistakes. The idea is that you learn from the mistake. And the reason I'm telling you this is that DWI is humongous business in Texas. There's a $3,000 surcharge that attaches to you when you pick up a DWI. If you have a 0.15 or above, it's a $4,500 surcharge. If you don't pay it, you do 1 day in jail for every $100 that you owe. Did you ask me to waive this?
Yes, Honor, there's a bit of confusion because when I was talking to the district attorney's office, they said that they would waive the fine. So is this a different? Yes, sir, I'm sorry. Yes, Your Honor, of
And
course.
the point that I'm trying to make, waive it. This is a first offense. We all make mistakes. But if you continue to make mistakes where you're endangering other people's lives, a second DWI, it's a $6,000 surcharge. And in a 30-day minimum jail stay. Do you understand?
Yes, sir.
So if you want to get lit, if you want to have 52 shots of tequila, 35 joints, just don't get into a car. It's not hard. After the probation, can't do it now. You understand?
So,
All right, how do you plead to the offense, sir? Guilty or not guilty? I'm gonna find you guilty. I'm gonna follow the agreement. You look for his license to see whether it's suspended or not suspended, please. I'm not gonna suspend your license. I don't know if your license is suspended now, though. We're gonna look it up to see if it is.
It is suspended, Your Honor. It's not illegal.
Okay, so
He needs to just pay a reinstatement fee of $125 for him to.
is there an ALR suspension or no? You're not allowed to drive.
It is an ALR suspension.
When does it run, do you know?
Until June 10th, 2025.
So
We anticipate filing a request for occupational driver's license.
you can't drive now. If you drive, and I don't care what you got to do, I don't care where you got to go, I don't care if there's a burning building, you have to save 50 kittens. Don't drive. If you do, you're in violation of this probation. If you drove here, you cannot drive home. Do you understand? Don't do it. So I'm happy, file it and we can talk, but
Okay.
don't drive until you either get an occupation or get the license back. Do you understand?
yes, sir.
So because of that, he'll get a portable device. All right. Good luck to you, Mr. Roberts.
Thank you, sir.
Thank you, Mr. Farrar.
Thank you.
Good luck. You don't take things seriously. You don't take us seriously. You had your first bond violation report the beginning of March for failing to go take a drug test. And now a new one was filed because you now picked up a new case. We are going to do probable cause on your new case. You now stand charged with the offense of criminal trespass. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you. As you see, your lawyer is here with you on Zoom now. Please.
On March 19th, 2025, an officer was dispatched to an assault in progress, unknown weapon at City Plaza condominiums in Harris County, Texas. The complainant, a security officer, stated that she saw the defendant walking around the security office, which the complainant found unusual. The complainant stated the defendant went near the exit gate and was waiting for someone to come and exit through the gate. It was waiting for someone to come and exit the gate so he can get inside the complex. Complainant stated someone exited from the gate and the defendant got into the complex. The complainant followed the defendant and told the defendant that he needs to leave the property because he was criminally trespassing at the property. The complainant stated that she told the defendant several times to leave the property, but the defendant did not listen. The complainant stated the defendant laid on the ground, the defendant stood up, the defendant started taking pictures of witnesses, and the complainant came in between witnesses' motor vehicles so the defendant could not take pictures of license plates. The defendant was identified by his Texas driver's license.
So at that point, do the cops come up there and they just arrest him there? Does it say? Does it take off?
Also, it does not state in the DIMS at what point he was arrested. Also, something that was missing from the summary was that a witness stated she saw the defendant punch the complainant and then they had a fight.
He punches someone.
That's what the DIMS states.
Mr. Gomez, I'm going to find that there's sufficient probable cause to go forward with your case because of your failure to comply. Repeated failure to comply with your bond conditions. I now revoke your bond. He goes with you. James, I will leave the criminal trespass bond as is The DWI now is at 5,002 and will stay at 5,002.
Yes, Judge. So he has a PR bond on the criminal trespass?
I don't. Let me see. No, he actually made a surety bond on the trespass, so I'm gonna keep that as is.
Okay, thank you, Judge.
Other case will, so Kayla, I need you to do me a favor on bond conditions for him. If he is released, he's to be released with a GPS monitor and he's not to go anywhere near the complaining witness and nowhere near this complex, 500 feet, please,
Yes,
on the trespass.